It's 5:03, so the recess meeting of the Planning Commission, City of Lancaster, will please come to order. Vice Chair Hall will lead us in an invocation. I'll lead us in the pledge. Please stand.
Thank you, God, for blessing this meeting tonight as we navigate these contentious waters and come to a quick and sure resolution. Thank you, God, for allowing this nation to move into this election that we're about to have in a few weeks. Please help us make the right choices. I pray in your name. Amen.
Amen. Please join me. I
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Thank you. Have the roll call, please.
Commissioners Diana Cook.
Present.
Miguel Coronado. Absent. Cassandra Harvey.
Present.
Sandy Smith. Here. Vice Chair Randy Hall.
Here.
Chairman James Vose.
Here.
We have a quorum.
Thank you. Yeah, Commissioner Coronado apparently called and said he was running a little bit behind, but since we're on deadline, we want to move through this item. This is a recess meeting of our Monday night meeting on a item that we've had 3 public hearings on the Lancaster Municipal Code Amendment Medical Cannabis Cultivation Ordinance. So the public hearing is still open. Do we have any speaker cards?
I have no speaker cards, Mr. Chairman.
All right, thank you. May we have, do you have a staff report then to share with us other than what has been written?
I have no new staff report other than to state that we circulated to you a markup addressing in the draft ordinance the 5 points that had been identified in the prior staff report and setting forth suggestions, ideas for how to address those 5 points in the text. You should have received a black line and a clean or red line. Is this colored? It's colored. It's a red line. Identifying where those changes were made, and that I hope will help to streamline tonight's process.
Very good. Thank you. Anyone have any questions?
If it's the chairman's pleasure, since there's no public comment, it would be all right to close the public hearing at this time.
Okay. Thank you. We have one member of the audience who doesn't look like he wants to chat with us. So any objection to closing the public hearing, members? All right, then the public hearing is closed. And it's time for the commission then to deliberate, in effect, on the 2 items. I think we should take up number 2 first, which is the revised 3rd revision of the draft ordinance that Ms. Burns pointed out. There are five points that we've been considering. We also received and was distributed. We also received an email, or I received an email, which I forwarded to Mr. Ludicky, which he shared with the members today, I believe, right?
Yes, that's correct.
And that was an email from Ms. Seelan, who has testified before us and represents the medical cannabis industry, or a number of clients in that industry, not necessarily the whole industry. Anyway, she was reiterating some of the points she made at the previous hearing. So that was shared with you all. You have the opportunity to review it previously. So if you're ready, the 5 points are that we discussed. And staff has made a recommendation on the definition of what a canopy is. And that's 5.56.020 canopy. If I'm reading that right. So can we, a question I would have, can we assume from that definition that we're talking about either a single level or multi-level growing area? Not the, I have no, other than what we've seen in a growing facility. I assume it's possible to have multi-level depending on how high your ceiling is, right?
Yes, I think that's possible.
So this definition assumes, and this whole proposed ordinance is based on floor area and not multi-story growing, in effect. I don't know how else to say it.
I think I understand what you're trying to get at, and I would interpret canopy as defined in this draft as including each level of any such canopy area. So if there's one level that's 10 square feet and then above it there's another 10 square feet, that would be 20 square feet of canopy.
Okay.
That's how I would interpret it. I would be happy to take a stab at writing that in, but that's how I would interpret it and encourage staff to interpret it.
Okay, so as long as it's in the record and we clearly understand what it means, that's really what's most important, right?
Right. So if that's the commission's intent, I think we're all in agreement that that is what we mean by canopy is each.
Anyone have any questions about that?
Could it be as simple as just saying, parentheses, total growing area? I mean, if you're,
That gets difficult.
What's that?
I said that gets difficult.
easy gets difficult.
Yeah, it does. And I think by saying the horizontal extent of the plant or combination of plants, that means each horizontal. We could say each and every horizontal extent, I suppose we could put in, but that seems overkill to me, but I could be persuaded to put that in.
Wordsmithing to the nth degree.
Writing by committee can get problematic. I think we've got it covered, but it's because it's the horizontal extent, and I don't care if you stack them on top of each other or not. That's still the horizontal extent.
Well, with our field trip that we took, it became very clear that there's going to be difference in square footage of the building and square footage of the canopy.
Correct.
And your language here that talks about that makes that clear. And
Right.
Chairman Bowes saying that this is going to be on the record is our intent. And that's how I understand it. It's not 22,000 square feet of building, it's 22,000 square feet
Of plant.
yes. And
Yeah.
as Ms. Salon said, that they may need as much as 35,000 square feet of building to work with 22,000 square feet of grow.
Right.
So that's how I understand canopy to be written here.
Commissioner Coronado has joined us, so now we all have all of our 6 members here now. Thank you. Sorry you were running a little bit behind, but we're on schedule. We're rocking and rolling here.
Sorry, guys.
All right, very good. So the issue then of 5.56.020 is clear in everyone's mind what that means. The next item is 5.56.030, capital letter C. This was the issue we've thrashed around with, and the recommendation is the maximum number of local licenses issued by the city may be limited by resolution of the city council, may be limited by resolution of the city council. It doesn't say shall, it says may. Such limitations may be based on the number of local licenses, the aggregate area of medical cannabis cultivation facilities, or any other measure determined by the city council. So Brent Favre has gone back for a pass, and we are ready, as long as the receiver is in place. All right? Any questions on that one? Pretty clear. Anybody uncomfortable with that?
So this is going to eliminate the 2010-5-2 thing?
Let the city council decide what they want to do if and when they take up the issue.
That makes me happy.
Okay. All right. And the third item is 5.561.130 M5 small d.
The language here is in place of what was previously a bracketed comment that said other grounds for denial.
Right.
This was another grounds that I thought of.
Okay.
I have no great pride of ownership in this language. I welcome comments, questions, changes, alterations of each and every kind.
I think there'll be some. It's on page 14 of the red line.
You said that was D?
Small d.
Yeah.
I do have some
Please,
comments.
go right ahead.
Okay, so I've really, because I brought this up the other night and just been, actually had a few conversations with some law enforcement people, deputy DA that I know.
Uh-huh.
Kind of. And just kind of throwing it out there. When you say I think Ms. Sellen brought this up, I mean, when you say a criminal conviction, where am I looking? I'm looking for the wording here. Oh, convicted of a criminal offense in the past 5 years.
10 is what it says.
Oh, it says, the D says 5.
Mine says 10.
Mine says 5.
How,
The corrected version says 10.
Okay, well, I've got two different copies here. Okay, I'm looking at the wrong one.
The re-
You're on the red line. You're not on the red line.
But that's what the one that was in our folder.
Oh.
Yeah, the one in our folder says.
the red,
Anyway, the point.
Anyhow, so the point is,
A number of
whatever
years.
number of years, so 10 years. My thought is if somebody gets a reckless driving conviction or a DUI, you're kind of, when you talk about people make mistakes. So my recommendation would be that it would be felonies, violent crimes, and any crime that is considered a strike. And drug sales.
so you want it to include not all felonies.
Drug sales, violent crimes, and any crime that is considered a strike.
So is there a way to define that simply?
And there is a list of offenses that are considered strikes.
If we say drug offense, Commissioner?
Sales, not offense.
But any offense, right? But of drugs.
Sales.
Sells, yeah, so here's the situation. So, I don't know, a person sells less than an ounce or an actual ounce.
Not a felony.
That, it's not, but it sells. So
No, that falls within felony.
that would be a felony?
No.
So if you're selling a truckload of
Yeah.
whatever, that's a
Absolutely.
felony. Yeah.
Yes. But what happens
So I'm
if
not
you're
talking
selling
about you selling someone a
Oh, okay.
little bit of weed, that's,
Yeah.
I mean, that's
She's talking about an amount that.
Yeah,
felonies.
yeah,
I'm
something
talking
that
about
could go to a felony.
felonies, yeah, because I think you can start dabbling in, 10 years ago, somebody shoplifted, a piece of bubble gum from Circle K, whatever, and which is a misdemeanor, and which you can just go home now, but, from Rocket Fizz, I'll throw that out there. But,
Different, that's different if they steal at Rocket Fizz, though.
right, that's a felony,
Oh, so that's a felony, okay.
yeah.
Commissioner Smith, may I ask, are you also including possession for sale at the felony level?
Yes,
Okay. And you mentioned violent crime. We've had, I don't know if we've had conversation here at the Planning Commission, but at City Council, we had a very in-depth presentation on Prop 57, which will be on the November 8th ballot, that has to do with criminal sentencing and eligibility for parole, and one of the crux matters is what constitutes a violent crime. Currently, there are only 23 felonies that are specifically called out as violent crimes.
Right.
Are those what you're limiting it to?
that's, yes. And anything with this that is considered a strike in the three-strike law. So there is a list available of, like you said, those 23, and then plus what's considered a,
A strike offense?
strike offense.
Okay, all right.
That's today.
If Prop 57 passes, three strikes in a lot of ways essentially goes away, so there's that. And I do just,
If that assuming this recommendation goes forward, and if that happens, then one would probably want to revisit what we have on the books. I mean, the world changes.
that's,
And I would hope, and, I've had this discussion too, that the owner of the facility would use, due diligence and good judgment in hiring the people that are going to be working there, but it's just that extra layer.
It's probably not very likely that a convicted felon who has been trafficking in illicit drugs would be hired
Right.
in any legitimate business, assuming that the owner knew. I mean, people get hired all the time who are, playing hide the football.
But then again, there's a lot of organizations and companies that do background checks and for a lot less will not hire you, so.
Oh, absolutely. Absolutely. Particularly that interact with the public, but, well,
May,
if you're bolting airplanes together, you can't, you're not going to get hired. All right? Even for most misdemeanor.
For a lot of misdemeanors,
may I make a suggestion?
Go ahead.
What if we used Commissioner Smith's list and then added language, or such other criminal offenses as the city council may set by resolution?
Ooh, I like that.
that would allow us to include or to recommend to council misdemeanors as well as some felonies, and we could throw in some of the violent crimes that are not expressly defined as violent, such as solicitation to commit murder of a peace officer.
Probably switch with. I think you probably meant, you switched it, so you meant felonies and some misdemeanors. You said misdemeanors and some felonies.
Well, both, really. This list right now, we're just talking about felonies, so we would want to be able to include other felonies to recommend to council to include here, as well as a number of misdemeanors that, off the top of my head, I can think of a few.
So it wouldn't be any felonies?
Well, if you
Just-
think, yeah, it's,
That's the recommendation right now. I had said it with all felonies, and Commissioner Smith is suggesting that we limit the felonies to possession for sale, that at the felony level, drug sales at the felony level, the violent crimes, the 23 crimes, or any crime considered a strike under the three strikes law. I suggested we added, or such other crimes or offenses as may be set by the city council by resolution.
yeah. I'm good
That
with
way, we can be nimble with regard to changes in the law without having to come back with ordinances after ordinance after ordinance in the hearing process and all of that. And I think that's the type of thing where those changes are ones we can do by resolution.
So these are the people that will be prevented from working here? Or will they only be prevented from working there if they've done it within the last 5 or 10 years?
10 years.
I wrote it as 10 years. I have no problem with changing that, but my understanding is we wanted to put it within a time frame, assuming that people can be rehabilitated, and if you've come clean and are leading a good life for a period of time, then that was a discussion that you guys had at the last meeting, that
Yeah.
you didn't want it to be forever barred. And so I had put a 10-year period in there, thinking that was a reasonable period of time.
I'm good with 10 years.
I have
How about 5? Because 5, I mean, 10 is really, I mean.
The
10
liberal speaks.
I'm sticking with 10.
I'm, based on what you just said, and being someone that, as you guys know, grew up in the street, and there's a reason I became an activist, and now I'm here with you. 5 years is a very long period. For example, if a resident of the United States, a legal resident, commits a, I don't know, drunk driving, for example, if he wants to or she wants to become a citizen of the United States, they would have to wait 5 years to be able to become a citizen of the United States. So it's reasonable. Another example is you get a stop and they find drugs on you, and they let you do PC, I think is 1,000. They in 18 months and then 3-year probation. And after the 3 years probation, and if you don't commit any crimes within 18 months, then it's erased. So I'm thinking or proposing 5, because if a person at 25 gets in trouble, by 5 years he's 30, and add another 5, that's 35. So I think that 5 would be sufficient to allow someone to work in this kind of business.
Well, I think
And-
when you're talking drunk driving, a DUI, as opposed to, and possession of drugs is a very different level than armed robbery and, a large amount of drugs for sale. To me, it's two different things, and that's why I didn't include the misdemeanors, like the DUI. The DUI is not a felony unless it includes bodily harm, right? I mean, if you
Yes.
get into an accident or hurt someone else, that's when it's considered a felony, and that's a whole different thing.
But
So-
I'm talking about as far as, I'm sure everybody could rehabilitate at different times. So giving someone 10 years, as you got in trouble, 10 years you can't work here, that's a long time. I'm just saying that I would support probably 5.
And I'll be perfectly honest, the explanation you just gave as far as citizenship, if that's only 5, then that makes me start thinking maybe perhaps it should be 5, based on the examples you just gave. So is that fact, the example you just gave?
It is, because I was the one that actually had to wait the 5 years.
Okay.
No, I mean, hey, I didn't start as an angel here. You don't become an activist in the street.
No, I
and,
understand.
all that, by being, of course, I rehabilitated and I did well, and thank God.
So it is possible.
But you didn't commit a felony. I mean,
No,
it
no,
wasn't
no,
a felony.
no,
To me,
no.
it's a whole different thing, and that's just my frame of mind.
But what the other example, the 18 months, if a person gets convicted of, if somebody gets caught with cocaine, for example, like I just said, and they get in trouble, they give them 18, thanks to Janet Reno, by the way, and President Clinton, 18 months to complete the program and 3-year probation. So within 18 months, if you don't get in trouble and the 3-year probation, then they release the potential felony. So that's just in 3 years. As an American citizen, as a resident, the government makes you wait 5 years from the time of the so-called crime. And that's what I was pointing to. If the government could say, hey, you become a citizen if you just rehabilitate in 5 years, and if you get in trouble, you're probably going to get deported.
So what about the inmate who's served his 5 years in the lockup and comes out just as sweet as when he went in, or she? Then what?
That's a very good point, sir.
Also, too, I think that growing or cultivating medical cannabis is a lot different than working at McDonald's, where they can take them straight out of prison if they want to, and we probably should have a higher standard, and 10 years sounds like a reasonable length of time to me.
Well, there's other issues. I mean, I work with people in the construction industry on public works projects, including schools, where Depending on the conviction, there is absolutely no interaction with students. Other convictions, no problem. I mean, every circumstance has a different set of rules. And I said it, a point of view on one side, you can call it liberal if you want, or you can call it conservative if you want. There is no hard and fast way, in my opinion, that we can classify, that we can say what the heck the real number is, because every circumstance is different. But yet, we got to come up with something or have nothing. So it's have something or nothing, really.
Two other points that tie into this, if I may.
Go ahead.
One, does the commission want to include a provision that says any other circumstance that the city manager determines would threaten the health, safety, and welfare of the city? Just a catch-all for some egregious thing that we haven't thought of yet? And then I believe it's in here, but just to be sure, make sure that if any of these things were to occur, it would be cause to revoke an employee's permit as well. So if that's not already in here, which I think it is, I would propose that I add that before the next draft comes back to you for adoption.
And I would just add, if I may, the default provision for the city manager to make a determination on sort of if you will, a case-specific basis is pretty consistent through some of our other licensing chapters, at least those that we've sort of addressed in recent years. And additionally, some of the other licensing chapters, taxi, tow, massage, there's not exactly a sliding scale, but there are different years set for different kinds of crimes. So, for example, if you're applying to be a taxi driver and you have a conviction of a felony crime against person, you can't get a city taxi license.
Right.
But if you are convicted of
Possession.
whatever, something along those lines, and it was 5 years ago, or I think it's 7 years under that chapter, then you're eligible for the license. So that's something else to consider. I didn't want to make it more complicated. Sorry about that.
But you are.
Well, if there's a little wiggle room there, if even we stay a little, as Assistant City Attorney said, if they could perhaps present something or give them an opportunity to review the case, rather than, because if we just say that, there's a little wiggle room, but they still have to wait the 10 years. Is that correct?
Well, they would have an appeal right under our standard procedures, so
Yep.
they could appeal. If they applied and they were at 9.5 years after an attempt burglary, I don't know, then that might be a circumstance where they would be successful in an appeal.
Well, another thing to consider is, the sentences of, 10 years from now, 10 years ago are going to be different than they are now. Example, 10 years ago or 5 years ago, somebody stole a TV from Walmart. That's a big crime. Now, it's not. They just give them a ticket.
Right, and that's why it's written that if committed on the date of application would be able to be prosecuted as a felony. That's why the language is written the way it is.
So it gives the flexibility.
That was the goal.
Conviction 15 years ago, 10 years ago, 5 years ago, for a strike crime,
right,
or whatever the category is now considered a misdemeanor and a traffic ticket, then there's no sanction.
Correct, except for the possibility of city manager or designee determines that it would threaten the health, safety, and welfare. That's our catch-all.
But that catch-all's already in here, and that's a subjective point of view that city managers or his designee have. I mean, the purpose, as we previously talked about, the whole purpose of this whole process is to support the establishment of this new industry in the
right.
community.
Right.
And not
legislated
where
out
it
of,
cannot function. I mean,
right.
What's the point?
Right. I agree.
I don't think any of us are of a mind that we want to limit and tight, make it so tight that the industry can't function.
Right.
And obviously, if that person is out of a job, then they can't spend money in Lancaster like it says on my license plate.
Buy more Lancaster.
Buy more in Lancaster.
Yeah. Shop Lancaster.
Shop more, that's what it is.
Yeah, so that, just give them a little wiggle room, you know? I'm sure if they're gonna try to sell at that level, the owner of that establishment, you know, they're gonna know that they're gonna shut their business down, especially Lancaster. Lancaster's strict. And I'm sure we're not gonna just deal with anybody, you know, run amok out there. I don't think we're gonna allow that.
All right, so are we resolved on that issue?
Can I repeat back what I think your resolution is? So that I can write it down later?
If I asked the question, are we resolved on that issue?
Shall I repeat to you what I think it is?
Go
All
ahead.
right. The employee has been convicted of a crime within the 10 years preceding the date of application, and I'm going to write it up better, but I'm going to try and say it right now. That would include possession for sale at a felony level, drug sales at a felony level, a violent crime as defined by codes, that's the 23 crimes, or any crime considered a strike under 3 strikes law, or such other crimes or offenses as may be set by the City Council by resolution within the preceding 10 years. And then another item E would be any matter that the city manager or his or her designee determines would threaten the health, safety, and welfare of the citizens of Lancaster. And I will also be adding a provision that anything that violates 5A through now E would be a grounds for revocation of an employee license.
All right, I understand it.
Sounds good.
Yep. Okay. All right. Then into Exhibit B, 1743-110. Which is on page B11 of your red line. Well, I'm sorry, there's 2. On B10, I beg your pardon. 1743-110A, number 1. So it says the medical cannabis cultivation facility shall be located A 600 from a religious assembly. Can't say church because that's not appropriate anymore, right? Never mind.
That's correct.
1,000 feet from a public or private school, college, or university. 1,000 feet from a daycare center. 600 feet from a residential use or residentially designated property, which is similar to what we have in all our other restricted uses. And 600 feet from public park. And 500 feet from a hospital. So if you read further on in the line items, we don't have any hospitals in industrial areas. Maybe we have
In the adjacent-
animal hospitals, but we don't
Okay.
have,
No problem taking it.
at least currently. But we have one, well, it's not a hospital, it's a medical building, it's not a hospital. Guess it could be someday.
I don't have a stake in whether that particular line item stays in.
Yeah, I don't know. I mean, this is what you folks have suggested for our discussion, which I asked you to come up with recommendations, so thank you for doing that. So, what do you think, folks?
If we leave it, should it perhaps say clinic or hospital or medical facility? If we were to leave it as opposed to saying hospital, based on what you basically just said, if we don't have any hospitals that are near any.
Don't
That
have it.
would likely be very complicated.
I realized it as soon as I said it with all the medical facilities we have.
Right. I think that might be too restrictive. I'm remembering this is not retail.
I didn't know. You're right.
I think we should take it out.
Yeah, in that case.
I think we should just take it out. I don't think it applies, and I think even if a hospital popped up next to one, there's no retail, I just don't think it would be a issue.
I'm
I
in
have no
agreement with
objection.
that.
Yeah, it's fine.
Just strike
E,
E.
We'll do so.
what about B on private school, college, or university? Like in the Fox Field corridor out there, they have the A&P school. And so somebody would want to have a medical cannabis grow facility within that distance. Would that be considered a private school, college, or university?
What kind of school?
Airplane and power plant?
Oh,
I
a trade school,
I
right?
think how we might handle that is sub 2, which allows for a waiver of the distance requirements. If that were to arise, they could seek a waiver. But I
We would do that in the CUP process?
yeah.
Yeah, the challenge with this, I mean, and I've done some personal research. I asked others to do some research on availability of facilities, buildings, lease, purchase, land, yada, 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 plus my own company's information. And, you know, setting a standard today based on what we see in our community and what exists today, you know, what it looked like, you've lived here all your life. It's changed considerably, right?
Well, it was, the east side was the good side of town.
Right,
It's where everybody wanted to be.
right, and it changed,
It changed.
yeah. So,
Courts Hill always flooded, too.
Not
yeah,
anymore.
and so did North Avenue I, and it still does.
Most of those.
Anyway, so my point is that we're trying to craft something that we can deal with today, but that's why we have the waiver process. So if there's a trade
so.
school who often locates in an industrial park, let's just say a religious assembly, can't say church, right? Okay. So they then would know that there's a distance requirement, and we've had this happen before, where they acknowledge that they're adjacent or near a sensitive use. And the applicant, in effect, waives the condition, rather than even coming to us to ask permission, if you will. So, I mean, it works, and it has worked for years, right? So everybody's comfy on striking E?
Yes.
If the medical worker is comfortable with striking it, so am I.
Yeah. Okay. We have an excellent cross-section of commissioners who have really a very broad view of our community and are involved with many, many, many different businesses, currently and previously. Okay, so the next one's on B11, number 4, at the top of the
Chairman,
page.
Chairman Bose?
Yeah,
Yeah, I apologize, and probably in trying to get all these things, the red line did not pick up the change but it is in your clean copy.
which what now?
On B11, number 3 at the bottom, that language has changed in the recommendation, and that is the allowable zones.
Oh, the allowable zones, yes.
Yes, but it wasn't picked up on the,
Well, let's address that then. May be located in property within Fox Field specific plan zone, which is a very large industrial area. All heavy, it doesn't say all, but heavy industrial zone. In addition,
Can it say all
Actually,
industrial zones?
the clean version I'm sorry, I don't know what happened with the black line, and I apologize because I think that's on me. But the way the clean version on page B11 reads is,
Let me look at it,
a
'cause that's
facility
not
may
what I
only be
read.
located, do everybody need to get to page B11 on the clean? Within the light industrial zone,
Right.
heavy industrial zone, or any adopted specific plan that permits industrial uses, and following the application for and granting of a conditional use permit in accordance with this chapter.
So it doesn't call, yeah.
It doesn't call out Foxfield specifically, but that Foxfield would be within the adopted specific plan that permits industrial uses.
Okay.
And there are others.
So the red line, black line, blue line, pink line, didn't pick it up, but it's on the actual.
I don't know what happened there. I'm sorry about the black line.
That's all right. I just read it and I thought, well, that's not what I read earlier.
Yeah, I don't, computers, let's blame them.
So, our specific plan areas, besides Fox and besides the, whatever it's called, off of Division and between K and L, everything south of L, there's also, that's industrial, but the specific plan area on the west side of Sierra Highway, south of L4,
L4 to L8, I think.
whatever,
Something.
yeah, which has got all infrastructure in it and a few buildings.
Correct.
So that's really everything in the community that has any industrial use for all intents and purposes, right?
Yes.
But we're not excluding anything in the industrial areas,
I don't believe so, no. I don't believe so.
but the distancing could, but there's a waiver
Could,
opportunity.
but there's a waiver provision that's there.
You comfortable with that?
Yes.
Okay. So, is 4 okay? Look at 4. See, and page B11. Oh, okay. Go ahead.
Are we referencing the 22,000 square feet in relation to the canopy size, not,
Yes,
Yes, that's why, yeah, canopy area.
okay.
and it's capitalized, so it must be right.
And it is the defined canopy, which is what we were talking about at the beginning of the
Initially, yeah.
conversation.
I'd like to ask a question. Let's say somebody has a 100,000 square foot building and they wanted to have that divided up and it's one applicant. Would he be able to have 4 licenses to grow in there or 3 licenses? Is this
Depends what the,
flexible enough to
depends
deal
what
with
the
that?
city council adopts for their licensing process.
Yeah, it's going to depend on how many licenses are allowed and how that's all structured by the city council under the resolution that doesn't exist yet.
They want to say, well, we got 50 licenses available and, you have no more than 7. Who knows? Or 2 licenses and you can only have a half one. I mean, I don't know. Remember, Mr. Favre had gone back for a pass. Okay, you good with that, everybody?
Yes.
I want my wallet back here in a minute. I tell you, okay. Where are we now?
I think we're finished.
We're finished with that. So,
Now the hard-
any other thoughts? Any other issues within the document as proposed that we need to address before we consider voting? Anyone? So if we drag it out and it's 14 minutes, I have to take everybody to dinner, including Lee. Richard too, probably.
Yes, of course. They like each other. Lee and Rick like each other very much.
Susie would want to go, probably. I don't know your wife's name.
Sir, she'll be very happy to join us.
Okay.
And I'll call John.
Johnny will show up, yeah, okay. Do they have a table big enough?
Well, the staff too, they work very hard.
Okay. You know, once we're done with this, the offer is there. Once we're done with this, and the city council takes an action. Now that could be, we could be having a meal in the springtime. We could be having Christmas lunch. We could be doing anything. So the offer's there, you guys. Hard work. All right. Nobody wants to make any other modifications. You ladies and gentlemen are okie-dokie over there?
Yeah, I think we've addressed the outstanding issues, and I can get you a cleaned-up draft that addresses the things we talked about today.
Okay.
The only other thing, I beg your pardon, the only other thing I would ask if we could have Ms. Burns do is just throw in our catch-all phrase that the city manager is authorized to promulgate regulations to implement this chapter, because there are going to be some things that we forgot that we're going to need to somehow account for down the road.
And ultimately, the city council is going to deal with whatever they deal with. Okay. All right with everybody? You're not suggesting, are you, that we should not take action on what we just fine-tuned? You're not suggesting that, are you? Are you suggesting we should take action on what's before us and what we've modified by consensus so far?
Sure.
That's what I thought you said. Is that okay with everybody?
Yes.
All right, so this is item number 2 on our agenda. So we're open, the chair's open for a motion on item 2.
I make a motion to recommend with modifications to the city council the draft ordinance attached hereto, adding chapter 5.56 and chapter 17.43 to the Lancaster Municipal Code, with the finding that it provides adequate safeguards to protect the general health, safety, and welfare of the city of Lancaster.
Second.
As amended.
She said with modifications.
Yeah, oh, you did? Oh, okay.
Smart.
All right, and Miguel, you did? All right. Any further discussion? We ready to vote? Please vote. Okay,
Motion passes 6-0.
thank you. Item number 1, which is a vote to support or not support the concept of allowing commercial medical cannabis cultivation facilities to locate within the city of Lancaster. So we're open for a motion on that one.
I make a motion to support the concept of allowing commercial medical cannabis cultivation facilities to locate within the city of Lancaster.
I second that.
Thank you. Further discussion?
This has been a tough one here for me to decide whether to support or not support, since it's still illegal at the federal level, and it's really hard for me to want to support it. But it is medical cannabis, and it is cultivation that does seem to alleviate suffering and pain in people. Just wanted to mention.
However, I'll add one however. I agree with what you said, but my belief is that this ordinance, once Prop whatever the heck it is passes, which I expect it will be easily modified for recreational cannabis cultivation, and that I find very challenging to support. I know that's not what's before us, but we've done the work, and it's easy to change a word. Even the red line system works for that.
It would merely be deletion of a single word throughout.
Yep. Anyway, that's all I got to say. So you all ready to vote? Okay, please vote.
Item number 1, recommendation is affirmative by a 5-1 vote.
Chairman Vo's voting no.
Yes. Consistent, that's all. All right, so, do we have anything else tonight? Thanks. Feels so much better.
Did you say it's heavy, Kelsey?
Yeah. Dollars in there.
So, this being a regular meeting, we have an opportunity for anyone to address the commission, non-agendized items. So if anyone would care to do that, you're welcome to. Nope? Okay. So we stand adjourned till November what?
I believe it's the 14th.
I'm sorry?
I believe it's November 14th.
November 14th? At 5:30 p.m. here in Park and Recreation Conference Room at City Hall. Thank you all for your work. And look at that, we're out of here in 53 minutes. Congratulations.